It's the New England Take. I'm your host, AJ Kierstead. Be sure to check out the newenglandtake.com, my brand new website I've put together for the show. Looking for partners if you're interested in having your writing, your video, anything like that published on the site. Please reach out to the newenglandtake@gmail.com. Already have old Rob Azevedo of Granite State of Mind throwing me some writing now and then, and I'm excited to have some more partners. So reach out if you're interested. Excited to be joined this week by Peter Lando. He is the founding partner over at Lando and Anastasi, a firm. His office is out of Cambridge, but they're very international firm as far as I know offhand. LAlaw.com to get more from them. So start off with Peter. Tell a little bit about the firm so people know that you know what you're talking about.
Well, we're an intellectual property firm. We're celebrating this year our 20th anniversary. And by the way, we moved to Boston, unfortunately, in March of 2020.
Whoops.
Bad timing to pick up the rent. But nonetheless, we're in Boston now at 60 State Street. The firm has been together for 20 years. I've been practicing over 30. Proud graduate of Franklin Pierce, and I cover all matters of intellectual property.
And that's where Peter and I met during my tenure as a staff member over at UNH Franklin Pierce School of Law. So be sure to still have good terms with that school. So excited to have you on today. I happened to see on LinkedIn last week, I think it was, that you were quoted in the Boston Globe. Their article was called "Banning Noncompetes Could Have Major Implications in Massachusetts." And I've kind of heard some rumblings around noncompetes, especially as the labor movement has really ramped up over the last 3 years as everyone's trying to move away from COVID and the fallout of everything through that. So there's a bunch of negative implications when it comes to non-competes. But generally speaking, from a legal perspective, it's a huge thing to consider. Like anyone that thinks this is like a 30-second explainer on the subject as possible is mistaken.
Right. And you know, it's true when you have low wage workers or non-exempt workers or restaurant workers, whatever it is. Sure. And it's easy to see that a non-compete clause in any of those contracts would harm the person, the employee, from moving from job to job. But that's not what I was referring to in the Boston Globe article. See, I deal in technology. So I think there's a kind of harmful impact here if this goes through, and not just in Massachusetts. Of course, the Globe was writing from that perspective, but this is countrywide, and it's up against a trend state by state, right? So California has long frowned on non-competes, and other states put limitations. And in Massachusetts, it happened in 2018, after many years of trying. They kind of found a middle ground, a modification to non-competes where there would need to be consideration or limited term or the type of employee, et cetera. And so here you have this, it's just the delicate issue, and the FTC thought it made sense to just ban them outright. And so they put this proposal forth, and in some of the language in the proposal, it from my perspective, again, coming at it from an intellectual property lawyer view, they're pointing out how this would open up the economy and prevent would-be entrepreneurs from forming competitive businesses, that inhibit workers from bringing innovative ideas to new companies. Well, my take is those innovative ideas were owned by the company they left. And so we have to recognize that ideas, especially in this day and age where information and embodied in intellectual property, right? Most familiar, patents, trademarks, copyrights, but of course, trade secrets. Trade secrets, that's what I'm referring to, confidential proprietary information and trade secrets. And the data shows on first of all the types of intellectual property, trade secrets are about 80% or more of all the intellectual property. And these are unregistered rights. So they're ideas that are shared and kept and maintained confidential.
And trade secrets can vary considerably from industry to industry, how small it is, even though it's tiny. Like that recipe for the McDonald's burger is worth an ungodly amount of money if another company was to then sell it. And then, I mean, what are they going to do? The cat's out of the bag.
Exactly. There's no putting that back, and there's a million metaphors for that. I like the horse left the barn, but whatever. but there you have it. So that's the risk. So you're sharing with your employees maybe how to do a process, how to make something, but the things that are published in patents, that doesn't tell the whole story. It's this know-how, this show-how, this confidential and proprietary information that can rise to the level of a trade secret. And as I was saying, most intellectual property, in fact, is in the form of some trade secret. And the other fact we have to keep in mind is most trade secret misappropriation, in fact, comes from employees and former employees. So the very people that have access to the trade secret, it turns out, are the ones, of course, that are the ones that, I'm not saying every employee is guilty of misappropriation, but that's where it must come from. And so here the FTC is saying, okay, now you can't put a non-compete in place with these very people. So how does, and they counter with, well, you can always sue them for trade secret misappropriation. Now, I don't have the statistics in hand, but it's a lot more expensive. I can comfortably and confidently say that it's a lot more expensive to sue someone for a trade secret violation than it would be to sue them on a contract breach, okay? There's a lot more hurdles to jump over in trade secret misappropriation. You have to show, first of all, that you, the employer, handled the trade secret as such, right? Mm-hmm. You use reasonable efforts to maintain it. And one of those reasonable efforts is contracts. Yeah. And so they're pushing back with
if you
this
can
very
solidify it with a contract. I mean, that's the easiest thing. You take it to court, say, hey, bloody blah, right here said he wasn't going to do this. This is the problem specifically right here. There's no rigmarole of years and years of lawsuits necessarily. It'll be done on the spot.
It certainly reduces the amount of issues you need to prove as plaintiff. And as you said before, even is true, even at that. So I have a contract claim, but my secret's out there.
Yeah.
So the damage is significant. And I think it's kind of lost, perhaps it appeared anyway, lost on the FTC to just outright ban without any moderation, without any intermediate approach, as was struck in Massachusetts in 2018. Where it's limited. I'm not suggesting that's the model, but some form of in between. And to my point, this was published in January 5th, this proposed rule of this year. And there's well over many thousand, maybe 10,000 comments already.
Wow.
That I think the Chamber of Commerce has asked the FTC, it's supposed to be 60-day comment period. And they've already asked the FTC for an extension on that comment period. So that's supposed to wind up in March. And I think it might end up being more like May or June even. And then once the comments are heard and a final rule is published, there you have it. So as a intellectual property attorney, in-house or general attorney or business person, you need to know this is coming in some form. It's absolutely coming in some form, whether it's a modification or the whole shebang. How do you counsel now? This is what's coming up. And it's not just, I want to quickly add, non-compete agreements, even non-disclosure agreements with a restrictive enough covenant within it, like you won't do something that can rise to the level by virtue of the FTC's definitions of essentially being a non-compete. Mm-hmm. So all of the agreements need to be reviewed in light of whatever the final rule looks like.
It seems like they're using a hammer to fix something that should have been a scalpel.
That's exactly perfectly said. Yes, right. And that's, I don't question government's intent. Maybe I should sometimes.
You should. You should. You can't on this show.
But I think that the many laws and rules, well-intentioned as they may be, are not well enough thought through. So I hope they take into consideration some of these comments. I did look at some of the comments. I didn't scroll through 9,000+ comments, but it's very easy to see the tension, right? Doctors, artists, restaurateurs, they're happy to see this go.
Yeah.
So
and it makes sense. I mean, that's the example where the lobbying should have paid off and said, well, this doesn't make sense. Some fast food worker that is told he can't work in another fast food restaurant for 5 years when that's literally your only experience and it's an entry-level job. How are you going to move into something else?
Exactly.
It is just corporate abuse. I guess another angle of this that people I don't know, but in theory might be against non-competes from the more libertarian free market perspective might be a matter of why the heck are these companies not allowing competition if this other employer across the street is going to pay you 3 times more to do the same job? Why not? I mean, I'm assuming that directly goes against the case for the part that probably should stay as is.
It goes against the part that probably
It
should stay.
should. We
Yeah.
probably should have the non-competes in those situations in certain
Yeah, I
situations.
think let's look at it from
Yeah.
one perspective. So there's some venture capital association. If you read the Globe piece, you saw some venture capital association, and forgive me, I don't remember the person's name, but they were pro getting rid of non-competes. And I was scratching my head and I thought, okay, I get their perspective, right? So they want to start a business. Of course, they want to bring in experience and people who are exposed to certain things. But play that forward a couple of years, and that very same company that started up is now a few years old. It's raised millions of dollars. It's trained its employees, and the knowledge there is unique to them as they pursue a unique solution in a marketplace, whatever that may be. And now, let's say a chief scientific officer or a experienced engineer leaves, or a business person, I'm not exclusively technology, someone leaves who has all the knowledge. I can't enforce a non-compete with that person. So they can go to a large, deep-pocketed company that could take right from under me the gemstones and start a business that will just knock out my startup enterprise. So it's not fair in a way, and when it's overused, as you were saying, a non-exempt employee example. And if it's not in place, then you have kind of a market free-for-all where employers then will have to have their guard up. How much am I going to share with these? So rather than show you the whole, I'll show you a part, and I'll show the next person a part, and you work together. Or it's going to stifle in-house innovation.
Yeah,
and sharing.
For with regards to the free market competition, it won't exist because you're basically, if you're just creating a duplicate company at essentially the same rate, same product, same everything, that's not feeding competition. That's just poaching.
Well, okay, I agree.
And that's what we saw a lot in San Francisco back in the early tech bubble days. I mean, they were just it's a very incestuous relationships between the Googles and the various other Microsofts and all them working alongside each other, sharing employees back and forth, which is part of the reason why there's probably so many non-competes now over in San Francisco Valley.
Well, they're all wiped out, right? Yep. So they're illegal in California. But you see a lot of that kind of in the life science sector in the Boston market. You see a lot of jumping around. And I've been in conference rooms where former employees of a company that we were investigating for one thing or another, the former employee of that company was in the conference room, and the pressure to have that person say what they know and the integrity for them to sit there under that pressure and not do it is very admirable. And I've seen that take place. And so I think a responsible employee will abide by the rules of the non-compete. And as I said earlier, most misappropriation is going to come from employees or former employees. So there's probably a whole lot of others that maybe don't understand what they were exposed to as to the terms of the agreement they signed. But there's unfortunately that happens from time to time. I'm also starting to look at this from the perspective of what it does to valuation of those companies, those smaller companies. When I'm doing a diligence, an intellectual property diligence on a potential acquisition, one of those, we always look at agreements that are in place, but now that you have to look at, well, who are the former employees and what did they know and where did they go? And so now it's opening up a whole vein of investigation, and I think potentially devaluing the companies they left. If you can see how their ideas may not be unique to them any longer because this person left with one aspect and this person left, and there's no non-compete I can show to stop that behavior. Now, again, FTC, well, you could always sue them for misappropriation. I'm a small company. I can't spend all of my raised dollars suing people all around different districts all over the country. And it's very tough to prove.
And the patent system is long and expensive, and it's not something that's just going to get turned around overnight. If your business could go under in 6 months if you lose the people that are there and the knowledge.
Oh, that's absolutely true. Whether it's patents or trade secrets or what have you, for many companies, it's bet the company and puts them in a position where they have to settle for unfavorable terms just to maintain presence in a marketplace. There's alternatives and things. I'm speaking in broad generalities, but I do think that it's a cost that and I might add, we're not talking about non-competes going forward from the rule forward. We're talking about anyone that's even in place as we speak, you and I. So companies would have to go and say, all right, here's all the non-competes we have in place and have had in place. And then you have to write to the former employees that signed those and say, never mind, you're not covered under the non-compete anymore. So have at
Chaos.
it. I mean, think about what that would, I just, as I said, I like to think that the government officials start out with, well, good intentions, but I'm a little suspect at this point on this one.
Yeah, I mean, if they're not specific enough with what exactly it is they're referring to with non-competes, I mean, what's kind of a worst case for like contract law in general if these went out? Say you got a musician that signed with a record label saying, hey, you're going to be doing 5 years or 10 records or whatever it is, and this gets written too loosey-goosey. What's going to happen to that?
Well, I think it'll be challenged because any whiff of a non-compete will be, well, it's basically banned. And as I said, even if it were in place years ago. So, if you're that artist and there's opportunity, but that's an interesting instance you raised there. I'm coming at it more from I have business information or technical information that could prove very valuable to a new employer. At the moment when somebody leaves, many companies' clients ask me to write the former employee and remind them of their obligation. And even the new employer, we write to and remind them that, John Smith here that you just hired from us has obligations to this company. So you need to, and maybe there'll be some of that continuing, right? I mean, they're not obligated under non-compete, but this person knows some things that we consider trade secret. And for you to ask or to kind of pry those away from them or incent them away from them by paying them more would maybe sweep you under the liability as well.
Yeah,
the trade secret misappropriation liability. Yeah.
Do you expect, because the comments especially have been so extensive to the FTC with regards to this, is it basically going to be a while before there's really any next steps?
No, this is this year, and it's months. It'll be months because whether that extension, and I'm just not 100% sure. I mean, last I looked, last I checked, it was, I think the business organizations were gathering and saying, look, there's so many comments here, and this is such gravity, this impact, it needs to be studied. And so they asked for it, and they may have it. I'm just not 100% sure, but it's interesting. FTC has the authority to extend that. And I think it's not going to carry on more than this year. The recognition of what the trends were, state to state, and even in the FTC, some of the holdings, non-competes. Non-competes have always been frowned on by the courts, and so you have to look at the context, though. That's what we've been talking about. In what context? It can be extremely unfair, yes, and it can be extremely unfair, yes, to the employer, to the employee. So we need a fact finder, and we need to put that into place and balance the harms, as it were. And I think that's certainly doable. And to write it into a rule, it's a difficult task, but I think it's doable. And if you just looked at the comments like a vote, it would be overwhelming to get rid of it. It was like every 50th comment was against it or something, maybe every 100th. So there weren't many. And I'm waiting for the business groups like the Chamber and other intellectual property groups like AIPLA or the IPO or universities. I'm not sure the law school wants to dip its toe into that, but maybe, and see what large groups think about it. Mm-hmm. Right. I'm curious about that. But this is happening in some form this year.
All right, well, we'll keep our eyes open for that because it'll be really interesting if it gets through. All right, speaking to Peter Lando, founding partner at Lando and Anastasi, LALaw.com to get more from them. Thank you so much for joining me.
Thank you, AJ. Great seeing you again.
This is New England Take. I'm your host, AJ Kierstead, the NewEnglandTake.com to get more from me, and follow New England Take on Facebook, Twitter, and Instagram.